well, what is the proper role of the grantor in context to a trust?
The grantor is the king, right? The trustee is the servant,
What
and
makes
pretty
it
much
so
in
heinous, B?
it was intentional. They at the same time they said the fires in London broke out.
Would I have the ability to go into whatever court is in play and somehow invoke the private side, as you said, have a private conversation? Is that an option that's always available, or is it only available under certain circumstances? How does that part work? Welcome back. I'm David Greenberg, and this is the Freedom Studio. As you guys know, we don't really have a strictly formal podcast format, at least not yet. However, it is important to me as an educator, as a content creator, and with my focus to have these occasional conversations with others who are bringing forth their knowledge and their expertise. And in the spirit of that, that's why I want to welcome B today to our conversation. And just to kind of set us up a little bit, I found out about B's work through his, um, principally through his YouTube channel, To Be Fruitful Training, because I was looking, as you guys know, being focused a lot on equity and trust law. I've been doing research on that, and that's kind of how I came across B's work. And because these are such important topics to what we focus on at the Freedom Studio, I thought it would be very valuable for us to learn what we can here and just dive in more into these concepts. So that's really the spirit of it. And I'll also just mention, I always try to come to these with a very high level of teachability. What that means is I'm just open to learning new knowledge. I'm not going to be naive and just, I'm not automatically believe anything I'm hearing, but I'm also not going to be this rigid skeptic who's just, shutting down things. It's kind of like that healthy balance between the two. And really, I encourage you as the viewer or listener to kind of embrace that as well. And I think we will let you guide the conversation through our questions and answers. But in the meantime, to start us off on the right foot, if you want to go ahead and introduce yourself.
Yeah, thank you, David. So my name is B. That's what I go by. I have the To Be Fruitful Training Group on YouTube. So I've been doing this, studying exclusive equity and trust law for now going on 6 years. Done a lot of different casework for myself, as well as you know drafting and other types of things. But that's one of the things that I specialize in is kind of court, you know, trust litigation and things of that nature. So that's really what I do.
Awesome. Okay. And then when you use this term exclusive equity, can you explain a little more what that means, the qualifier exclusive equity?
So exclusive equity generally refers to generally the jurisprudence regarding trusts, but it also encompasses the other types of equitable doctrines such as subrogation, exoneration, suretyship, things like that. Um, but exclusive equity has that particular term mainly refers to how trusts are cognizable solely in equity. So that's really where this term kind of got coined, and it basically refers to that whole jurisprudence of and that whole body of law.
Okay, so we're talking about trusts that are established in the equity jurisdiction. Is that right?
Yes, yes. So most of the time, like there's still, use for constructive trusts, resulting trusts, things of that nature. But in preventative measures, generally one of the best ways to kind of establish trust out of the gate is essentially, an express, it just means written trust, and then you're able to clearly delineate the terms of the trust agreement and the documents there. So.
Got it. Now, obviously, I explained how I came across your work, but in general, who out there would be looking for what you're teaching, like, and why would they be drawn to it? What are they specifically struggling with or looking to solve? Like, what is drawing people to your education?
Well, I don't know. I think I have a different take on it a little bit than most people. At least I think as far as who needs it, I mean, really everyone needs a trust. There are various types of trust that people need, and generally they should be purpose built, you know, for the specific situation. But I mean, everyone needs a trust, everyone has standing to benefit from it because, and most people know about, HJR 192 and the abrogation of the gold clauses in 33. So that's more of a commonplace knowledge in this space, if you will. So, but the other aspect of what people don't realize is that when you remove that lawful substance, one of the valid elements of a contract is consideration. So if you're lacking consideration on both sides, then it ceases to be a contract and a trust fills the void. So this is why, everything that we deal with, it's all trust law. Everything is trust law. So because there has to be something to hold these different agreements in together in the public. But trust doesn't have to have equal standing. So if you don't know who's giving the consideration in trust, then that's when the arrangements get misconstrued and things get fuzzy, especially with the way the public sees trust. So that's the importance of really, diving into trust law and equity, because it's not just trust by itself. You do have to understand, the other equitable doctrines to essentially, protect and utilize in different circumstances. But it's one of the most versatile and frankly one of the highest law form out there. A debtor creditor is completely subordinate to it. And all these, admiralty, maritime, all these other law forms, they're all subordinate to trust law because trust law is the original form of law, um, because of the rights, endowed to us by our Creator.
100%, 100% B. Uh, Folks who have been following my work know that I talk a lot about natural law, and I was probably speaking about it even before I really started thinking or speaking about equity and trust or learning more about it. So, one of the things that struck me about equity and trust law is it does seem, as far as our, man-made laws, it seems pretty close to, much closer to natural law. And I think that explains in part why it operates the way it does. I'm just curious, what are your thoughts on that statement?
I wholeheartedly agree. Equity is the spirit or the intent of the law, and the letter of the law is considered the legal statute.
Yeah,
So, if everybody clearly kind of knows what the legal statutes are like, they're kind of merciless at times, and they really just don't care as to the moral rights aspect of it, because there has been a separation between those two different schools of thought and conscience. So I mean, equity is that, what should have been right. That's that maxim. Equity regards as done what ought to have been done. So and those different maxims of equity, those are long-standing principles that have essentially been proven true to such a high degree that they no longer have to be proven themselves. They themselves prove other things. The only thing left is to find out and determine whether that particular maxim or principle applies to the current situation because they are generally true, but there are exceptions. So and in administering express trust and other trusts settled under exclusive equity, um, that it allows you to, if you so choose, or if it's the settler's intent for the trust, then you can settle the trust completely and entirely under just the laws, or of the trust, which is the or it's set as the maxims. You can there's a myriad of different things that can be done under trust because the intent and the purpose of the trust is the law of the trust. So whatever the settler was originally intending in their the way that they express their intent, whether it be by declaration or actions of conduct or other implied arrangements, uh, that's something that can be expressed and made known. So it is very controlling once the settler has expressed, a very specific intent purpose. Because the courts, as long as the trust isn't breached, and there's other factors there, the trust can't be set aside, it can't be disregarded, and even courts at that point, given the right circumstances, have to take notice and respect the settlers intentions and wish. So it's, because once property has been set aside under trust, it is under that law form of, well, whatever the law form the settler was under, and like I said, that, the settler's intent and purpose for the trust. So it has a lot of different benefits. I think that people just kind of gloss over it most of the time because they only hear trust and they think, oh, I know what trust means, and realistically speaking, people don't, you know, um, because it's there, there's four elements to a trust, valid elements, and then there's four methods of creation of an express trust. So you have the intent, the purpose, the specific res, and the parties of the trust. So those four elements must be present in that trust for it to be constituted and be seen in the courts and in law, or excuse me, in equity and chambers. And there has to be one method of formation. So those four methods are declaration, power of appointment, contract, and transfer. So there's a myriad of different things that constitute transfers under that. But as long as it meets those different elements, I mean, you have a trust, regardless of whether they want to acknowledge there's a trust there or not. So, that's one of the most powerful things there is because it's such an abstract concept at first, people, especially when I started learning it, it was kind of just like a head scratcher. I'm like, what am I really thinking about? That's just such a vague thing. And until I start the elements and how, the invisible ties, like in the mind, kind of arrange themselves when you think about it according to the substance of the transaction. So, and then knowing kind of what it has to be, what it isn't. So, you're kind of able to get that contrast just from that knowledge base or those principles, and then you're able to determine whether the courts are going to be able to recognize the trust there or not, which helps with enforcement. So, those are some of the biggest things I think, as with trust that people just maybe not aware of and probably haven't delved into as much, but they're very powerful and very potent.
As you're speaking about this, B, I can hear it's coming across, your proficiency, competence with this, and also to some degree your, your passion and I wouldn't say belief so much, but like your conviction about it. I'm just curious, how did this all come to you? Because obviously, like you said, most people don't know about this. I didn't know about this most of my life. Like, how did you come across all of this?
Well, it really started, more so with my spiritual beliefs, kind of like I said, I follow, the Ten Commandments, Torah, and the Tanakh. So it started with that, and then from there, I kind of started to realize I'm like, well, these things are set in place, and I started finding different things there. So I realized and found out that the original trust indenture was essentially the garden given to Adam. And from then on out, I was like, well, if this was entrusted to man, then man has become a trustee of that former estate. And if man is the indenture trustee, well then the Most High is the king or the grantor, right? So and then who owns everything? Who has the beneficial interest? Well, the Most High, because everything on the earth and in the earth belongs to the Most High. So it really that's kind of where it started for me. And then I mean that it was more, there is legal acknowledgement. Like I said, you have Public Law 97-280 where they really acknowledged that they codified the Bible as an actual statute. So, and it was in 1982 they declared 1983 the year of the Bible. So they did. It's not like it's just religious text. No, I mean like Congress literally acknowledged it as a statute. It was that potent and that foundational. So I was like, well, why is there this big disconnect? We have these creator endowed inalienable rights and, all these different things, but are people having such an issue and such a hard time basically just preserving those interests and those rights? And I mean, ultimately, that's what led me down to, okay, I need to study trust law again. I was looking at wealthy people and seeing how they move, money and how they preserve assets and all this stuff. And so I'm like, all right, it's got to be something involving trust because all these people are using it. Very, very wealthy people are doing this, so there's got to be something there. So I just started digging, and I kept studying and studying. Eventually, I found people like Christian Walters, his content, in various places on the internet, and studied his material quite extensively. And I found other people, listened to over the years. But I've read a lot of law reviews and um, things like that to really just kind of better understand it for myself. Because that's the other aspect is I tell people all the time you really do have to do your own due diligence because when you're in that type of situation, the only one that can really enforce the trust is really somebody with an interest in it, either the trustee, the beneficiary, or in some cases the settler. But if they don't know what can be done, I mean, the trust is almost unenforceable sometimes, and it that can sometimes cause a breach just like that. So, understanding the different aspects of it and getting that framework for what causes a breach of trust and how is it prevented, those are just that allows you to be able to see it in the mind. Because if you know where the boundary lines are in the mind, you'll know how to navigate. And that's why, like I said, I just had to study. I was like, okay, I want to know the core principles. I want to know these things. So, and it just made sense. You know what I'm saying? It just resonated with me. Some people, stick to certain types of law forms, but I mean, like I said, if I was going to deal with a law form, I was going to deal with the highest form of law, and that's, it's honestly ecclesiastical equity. That's the highest form of law, and natural law is probably the closest thing to it within the public realm.
Got it. Does ecclesiastical equity, does that include both equity and trust laws you're describing it, or are those two separate legal jurisdictions?
Well, there's some different schools of thought regarding that, and it's sometimes I think it's a little bit obscured because of the way that most jurisdictions are today. But truly and originally, like when I'm talking ecclesiastical equity, I'm speaking of like the original source authority from the Most High, and you know, uh, in my eyes, that's the Torah and the Tanakh, and the way that they present essentially the indenture of trust. Um, so that's what I mean by that. Now that is essentially the highest form of law because there's essentially everything that the Most High speaks comes into existence, and they always talk about the Big Bang. Well, the Big Bang was caused by the Most High. So it's just two different schools of thought. But natural law is a little bit, I guess, more secularized, if you will, not necessarily codified, but just what it how it's thought of, I guess. The actual law is not really different, but it's just, I guess, how it's presented. I just it's just a different mechanism of enforcement. So whereas the trust in and of itself, has a different that body of jurisprudence, especially when you're in that realm. But it just depends on what the law form you're going to use to enforce it. So that way you deal with recognition. They can't argue with certain things ecclesiastically because of what they've acknowledged. Natural law it's more like a trust under strictly exclusive equity. So strictly according to conscience, not necessarily ecclesiastical, not necessarily divorced from it either, but it's out of the public realm and still has some requirements to be able to enforce it. You have to have some layer of integration in the public, or at least in that public form of law. Um, the way that the common law has kind of been, codified with precedent to an extent. Now, and that's not to say that it's bad in any way. It's just you have varying degrees of slight jurisdictions. that I've had to study essentially each one to figure out, okay, why are there so many jurisdictions? And it was essentially just the process of time that kind of brought those around. So, and this is the other reason why, like, generally I tell people, look, you don't just need one trust. There's some that are common law, express trusts that can hold, corporate interests, commercial interests, and other things like that. There are some, different types of express trust, like you said, that can be settled entirely under natural law as a law form. There's some forms of law that can be settled under a particular statute, while still maintaining common law. Like there's a myriad of different ways to do it. Generally, it's just, what do you need for the situation? Because generally what the need will determine the purpose of the trust, and then but that has to be coupled with the settler's intent to actually set it aside for that particular thing.
Amazing. How for someone who's just learning this, so for example, just to use me as an example, I started learning specific equity processes and trust law in earnest only about like really less than a year ago as a committed process of education. And I just now feel after about 9, 10 months that I'm just starting to hit my stride. So my question is, for someone who's coming new to this, how much time should they expect to invest and how much effort before they really start actually creating their trusts? I mean, what is the initial commitment? What do people need to be willing to commit in terms of learning?
I think if you start out with like kind of the more basic things, you'll have to progress kind of to be able to administer all of those different realms or and within the name. But realistically, when you get down to like just the beginning and all that, like generally I tell people, you need at least a common law express trust, you know, settled, maybe kind of like Carlton Weiss's, Weiss Concise Trustee Handbook. That's a good reference as far as just a basic, you know, that's essentially a successor to Massachusetts Land Trust. So it has the ability to, own tangible, intangibles, intellectual property, and other land, real property, things like that. Tax administration is a whole other aspect to that entirely, but that's as far as just trust like that, that's a good place to start. And having another also a revocable living trust, a private, maybe foreign, something like that. The having those two is a real good start. Um, Now, when you start talking about reclaiming interest and other accounts and things of that nature, generally speaking, if you have like a commingled account, you'd want to set up a purpose-built trust to kind of house those things instead of just breaching your own stuff and putting all of those liabilities in one of your more private trusts. So it's not just trusts, but also accounting and segregation of deposits as well, because each trust in that essence would kind of be like its own, separate thing. But I mean, that's kind of what I tell people as far as what to set up. Now, in administering it and kind of getting used to that, you really just want to study like things like Gilbert's Law Summaries on the Law of Trusts is an excellent resource. Um, that's like the most layman's breakdown, I think, of trust. That's where I got those elements in the four methods of creation, like I mentioned earlier. That was directly out of Gilbert's. Um, there is Corpus Juris Secundum, which is Latin for the second body of law, and that is book 90 on trusts. That is a very, very good resource. That breaks it down with sometimes over 50 different case sites per subsection, detailing why something within trust is the way it is, with actual case law to back it up. Um, Another excellent resource is American Jurisprudence on Trusts. They quote the Restatement on the Law of Trusts. I believe that's third a lot of times. And like I said, those are excellent jurisprudences to study. Um, Once you get into kind of more out of the statutory realm, you've kind of got a couple things set up to kind of reclaim those commercial interests, then I would say, you kind of start looking at things like Lewin. I think it's a practical treatise on the law of trust by Lewin, 1888, or something to that effect. And that's when you start talking about Blackacre and estates settled with contingent remainders to, you know, to the heir and all that. Like it gets a little bit more complex. And that's more of like maybe like a private non-statutory trust as opposed to, some of the other things that are more statutory in nature.
Okay. Does it make sense, given the level of study required perhaps to really master these? In your opinion, should every family or every head of household dedicate themselves to this study, or are there ways for families and communities to aggregate their efforts in order to make this more efficient? Because it almost sounds like a graduate level study for everyone. What are your thoughts on that?
It's, I mean, honestly, like me personally, I would say everyone should study it. I realize that not everybody is in a position to do so, and yeah, it would be good to kind of do that type of thing. But the biggest thing about it is like really every head of household to be able to honestly and truly administer their affairs, they have to know trust law. There's really no other way around it. Otherwise, you remain a dependent, either dependent on the state, dependent on someone else, your employer, or something else. That's why there's so many people that really don't get into entrepreneurship is because, they want that guarantee. Well, guarantees don't, they come with a cost. So,
There's no such thing as something for nothing.
right. So, I mean, and that's the biggest thing is like you get in what you put, you get out what you put into this. And
Yeah.
it comes with great reward. You do have to put in the time, and it doesn't take years and years and years to understand. I was setting up trusts like literally my first year, even though I didn't know entirely. The biggest thing is if you don't know what to do with the particular trust, or it's of like, and it's not just like a domestic or operating either trust or company or, business entity, then I mean, really, you got to think about, okay, what am I really doing here? If you don't know, sometimes it's better to just set the whole thing aside and until you do, and then just kind of have the trust sit there and then essentially just let it sit there and hold because
I
it's
think
just
there
better
is a
to
balance point. There's a balance point between taking action because we don't want to be paralyzed
right.
paralyze ourselves due to lack of, I don't have all the information because
Yeah.
you're always going to be learning. So it is about finding that sweet spot and saying, okay, I'm at a point where I'm ready to take action. I have some mentors or some educators that I can go lean to if I have specific questions. However, I'm
Hmm.
not going to just keep putting this off into the future because otherwise nothing ever is going to happen. So
Right.
what's your sense of that?
I mean, there's a maxim on that too. It's, equity aids the vigilant, not the indolent. Or, and the equivalent, the modern equivalent would be, equity aids those that, essentially stands up for their rights and not those that slumber on them. Um,
Yep.
so
The
I
principle
mean,
of
yeah,
self-defense in context.
right, right. So there's with any situation that you really have arise, most of it's preventative that can, kind of keep it from arising. But when or if it does, um, you do have to move with a certain degree of urgency, just not with haste. So yeah, no, you're absolutely right with that.
When we were speaking briefly in the pre-show, you kind of alluded to wanting to bring forth or possibly mention a historical focus on how this started. Is there anything specific you wanted to bring up there, or what are your thoughts?
Yeah, absolutely. So I mean, a lot of these different types of trusts, especially in regards to the legal estate. The legal estate has more. It is a trust. An estate literally comes from the word statuo and the letter e. So it was e statuo. So it is a trust up under a specific statute. So it is a black or statutory trust. So the question is that most people don't really ask is what statute is it? So that particular statute is the Cestui Que Vie Act, or the Cestui Que Vie Acts plural. There were several of them over the years that formalized and established the procedures regarding people that were lost at sea, and people that were presumed dead. People are like, okay, well, why does this even matter? It's like, well, that capital letter name is considered a nom de guerre, which means name of the dead in French. So if you've ever gone to a cemetery, they only ever have their names in all caps, anywhere in there. So I don't know about anyone else. I'm not going to put my name in all caps like that. If it's going to be in all caps, it's going to be clearly delineated as a business that is controlled. So, and that's kind of the shift in paradigm that at some point just has to happen. So I mean, but the Cestui Que Vie Act started in 1483. So most people are aware of the one in 1666, and that was done by Westminster. Um, but the first one was actually in 1483 by, I believe, Richard III. And let me pull it up real quick just so I can quote the actual name. So 1483, yes, Richard III. And it was entitled The Statute Made at Westminster in the first year of the reign of King Richard III in the year 1483. All acts made by or against Cestui Que Use, which is the beneficiary of the estate, shall be good against him, his heirs, and fiat fees and trust. A fiat fee is essentially like a grantee, if you will. That's the closest thing I can think of. So, because a fiat is a transfer, a conveyance, and trust, or sometimes without trust. But they basically made good. There was an issue with the titles in England. Now, make no mistake, it was intentional what they did. The circumstances may have arisen and given rise to be able to allow this, but they had an intent to essentially alienate people's interests. So when you consider, when you read the act and you consider what it means, I mean, essentially, it basically says that they don't care whether the conveyance or the transfer of property is fraudulent, induced, forced, coerced. They don't really care. So they've essentially set in motion that as long as that signature is on paper and however it was obtained by whatever means, even if they had to, hold you at gunpoint, they're going to hold it as good. And this has been since, 1483. Now, there were several others that led, that followed that, and I believe 1488 and 1540. And, there was one in 1535, a few of them. But they ultimately just kind of formalized it with 1666 and gave a remedy for it. And they said that, if the dead man proved to be, alive, that the title is revested and, the executors or administrators of the estate could then, have, hold, and enjoy those said lands, tenements, and hereditaments and re-enter that said estate. And what that allowed for is that was the first codification, but that also allowed the remedy for the first time because there wasn't a true remedy to any of the prior decrees. So, and that is one of the most heinous acts I've seen, statutorily with regards to estates and trust law, and
What makes
pretty
it
much
so
in its
heinous,
entirety.
B?
Because, like I said, it was intentional. They at the same time they said the fires in London broke out and that Parliament burned down, and and they basically said that all the rules burned and all that stuff, but they hid the rules. They're still there. They just didn't tell anyone about it. Um, that's the real. It was intentional. I'm just not trying to go too far into this because I know who they are, but yeah, they know that they have all the records, going back thousands of years. They know who everyone is genealogically, even if you don't. So, but there was, this wasn't the first time this was essentially put into effect. There was a essentially an ordinance by William the First, William the Conqueror, where that he basically separated the courts from the spiritual courts from the temporal ones. And why this is so detrimental is because, the soul is considered ecclesiastical goods, and they were under, the church, or at least the spiritual courts, which had rule over, those matters. And then all the body, as corporeal thing or res, was generally given over to the secular courts in the secular realm. So if you had an issue regarding both the body and the soul, there was no venue for any type of recourse. And this ordinance was put into effect 1,000 years ago in the 1070s. So I mean, this was the original act that kind of preceded all of those different acts that gave rise to the situation in the first place.
Okay. From your opinion, what was the spirit and substance of that act? What were the creators of that act really trying to do?
They were essentially, I believe, it was more of an indemnification to make certain that some matters got strictly held only in the secular realm, and they could not further escalate to the spiritual courts. It was essentially like a denial of remedy for the soul, if you will, which is kind of why people have issues trying to claim the living man argument. So, that's.
What
Mhm.
issue? I'm not sure what you meant by that. Issues claiming the living man argument. Can you elaborate a bit
Um,
there?
yeah, absolutely. So, most people, well, in this space at least, generally have an idea of, if you've seen the videos, people going in saying they're living men and women on the land,
Yep.
when they still have the franchise that they have not properly claimed. So when they have that franchise that held in abeyance, or held in a pending state or in limbo, essentially they don't really see you. All they see is the fiction. All they
Okay.
see is that corporate entity that may or may not have an interest in. So when you quote the right things and you invoke the right authorities in the right manner, all of those facades just kind of fall away. So yeah, that's essentially what happens when you invoke it properly. But most people, and I know they intend well, it's just there's a lot of lack of knowledge regarding how it's actually done.
Is that something that you help your clients or your students to master?
It is. I do a couple of different things. I've been moving more towards like just having private mentees and things of that nature. I do have
Sure.
like a class and all that where I teach that kind of thing. But yeah, it is frustrating seeing like kind of seeing what's going on, and then just like wanting to help, but people just don't know what to do. And because really my main goal is, like I said, it's just to teach people what they should have known already.
For
It's
sure.
not like
We're
it's a big
we're
secret. It's
playing catch
just,
up.
well, right. Yeah, that's the biggest thing, I think. It's just really just studying, because once you study for yourself, they can't tell you anything. Because you already know. And when they try to pull something, you're able to discern what they're actually doing.
That's something interesting I've noticed just from watching certain, court cases or maybe more being, having stories related to me where somebody did something in particular or said something in particular that probably properly, pulled down the veils, as you mentioned. And all of a sudden,
Mhm.
everybody in the court, the judge is acting in a completely different way. And I found that very fascinating. It's almost like they have to act in a certain way when you invoke a certain power. What's your thought on that? Is there some deeper level to this that they're beholden to no matter what?
Absolutely. I mean, and there's a body of trust law. It's fiduciary law, and that's essentially just the Latin word for trustee. I mean, fid
Yeah.
means to trust, and area is like the state of, or the position of. So it's essentially somebody that's has something held in trust. So
Yep.
they are trustees. I mean, so fiduciary law, there's multiple types of roles that they don't publicly announce that are trustee or, trust relations, but executors are fiduciaries, trustees are fiduciaries, guardians, curators, parents, fathers and mothers, they're all considered fiduciaries, especially with regards to, their respective relations. And that's one of the things that the courts are bound to respect. It's just you have to speak the right language, and understand what is the jurisprudence regarding that type of trust law. Because when you invoke that word, it has a whole body of jurisprudence and case law behind that. When there's corporate actors, essentially even government actors, when they step outside of their lawful authority and they act ultra vires or beyond that, then they essentially step into their private capacity and they're, you know, liable at that point for the actions that they take, especially if they're acting in a, if they have an interest in the matter, you know, or a bias. So they can be bound to perform under trust in that regards. And that is very, very potent. All of them are bound by that, especially with the right precedents. So,
Would you,
yeah,
in your opinion, this is just an opinion, I'm just curious what you think. In your opinion, do most judges or many judges, do they know the deeper game that's being played here, like the deeper spiritual level, kind of being the bumbling judges that they sometimes come across as being?
I would say it's not as many as people probably think. There are a good number of them at the higher levels that know, but it's not in the numbers that people are probably guessing. It's, it's like maybe 5% of the judges, maybe. It's not a big number, because I mean, really, you're talking about, I don't know, maybe 10, 20% of the judges that already know trust and equity, which is more of a specialized doctrine, the way that the public perceives it. So, I mean, how many trusts and, estate law judges, that are sitting on those type of cases really even know this, you know? It just kind of, it becomes a very, very small number when that really, really know. Yeah. They might have inklings of it. They might have heard a thing or two, a lot of them. But yeah, I don't think it's as many as people think. There's still generally, one or two that knows in just about every building.
Yeah.
But yeah, it's kind of a hidden aspect, as far as they're not taught it, Pretty much no one on the board is taught it unless you study it yourself.
So what if you get in front of a judge who's clearly not in that smaller percentage? How do you, are you now in a position where you have to kind of educate them? I mean, how do we deal with that?
Pretty much. I mean, you do have to make sure that you don't breach your trust so that, things that are private generally are still held in the private, whether they be under, I don't know, privileged information or sensitive information, things like that. Um, but even then, whether the filings are sealed or unsealed, generally speaking, you do still have to give them notice and let them know, hey, look, these precedents are in effect. This is, the case, and applicable here and now. You do kind of have to give them notice and let them know and provide a, reasonable basis for someone that, whether if they didn't know, now they have at least enough to go off of with several, at least two or three witnesses to be able to say, okay, look, there's some substance here. I gotta, take a look into this. But again, it's more of formal writing, almost kind of research paper esque, maybe not as verbose, but kind of in the same vein of kind of having, if you will, the different, what you're trying to prove and then the multiple authorities or the points that you're using to prove it, the implications or the effects, and then, there are desired effects. Uh, so, I mean, all of those things they have to be addressed, properly to kind of cover and substantiate what you're actually claiming in court, whether it be public or private. So, you're absolutely right. Like, a lot of them don't know. And so most of the time you are educating them on that, and it's not, it shouldn't ever come from a place of malice. Don't get me wrong. I've had plenty of times when I've just been,
Sure.
ultimately you have to realize that, anger clouds and blinds people. So
Yeah.
you really, in certain aspects of this and kind of finding out what's going on and all that, you kind of have to go through a wild, different emotions of acceptance and all that, just to be able to just kind of process it and be able to just see clearly, because when you start finding out certain, it gets it's like, why is all this going on? Why is there no one's, correcting these things? And really it's partially because of our fault, uh,
Well, I would
we
agree with that.
have all the power to correct the situations that we need to. It's
Yeah.
just most people aren't doing it, and for either for lack of knowledge or just because they don't want to, It's kind of sad, but it's just like, okay, well, I'm not, I see why, what's going on in the public. I see that, but I'm not really looking to do that. I'm gonna correct the situation and take responsibility for what is my part. But the extra liability, that's not my fault, and all, what's been imposed on us, that part, nah, that's got to be dealt with, and
100%.
rebutted or, expressed. So
I agree with
yeah,
that wholeheartedly, and that's why perhaps like you, in my own way, I have really gone all in on the education aspect of what we're doing here because I have recognized from my own perspective just what you were saying is, it's entirely in our power to turn this around.
right,
And but
right.
it really starts with each individual. So for you who's listening to this, who's watching this, starts with you, man. Yeah, I'm just speaking, specifically to each viewer or listener. Yes, there is a collective nature to this, but really the real work starts with the inner work. And I think, getting your inner house in order, then getting your family affairs in order, which is like your own little kingdom, and then we start to collectively make a difference as more and more people manage their affairs. So I agree, this could all be turned around. I mean, I don't know how quickly it could happen, but probably pretty
Oh,
quickly if there was a cascading effect. What do you think,
it,
B?
oh, absolutely. Yeah, people think it takes forever and those things. If you know what to do, I mean, overnight it can change. I mean,
For sure.
it really can. I've had a lot of experiences like that where, yeah, it does just like things, you put the right paperwork in, the right filings with based on the right kind of line of reasoning. Oh my, yeah, it can really turn around even overnight. I've seen it happen. So don't think it takes forever and it takes hundreds and hundreds of filings. Like when you start dealing with private trusts, they don't get registered. They're
Correct.
accountable to the beneficiary only, not to the state. Not to say that if they, conduct commerce, they're not amenable to the state. I'm not saying that, but with truly private trusts that are, not commingled in the public, yeah, they can move very, very quickly to preserve those interests because equity doesn't just allow kind of post damage or post breach relief. No, like equity has the power to prevent the breach before it ever happens. So if you have evidence or of a prior breach and or intended breach, you can even bring an action under trust to restrain or obtain an injunction against that said respondent or defendant, and essentially it stopped them from even breaching the trust in the first place. This is where temporary restraining orders came from and injunctive relief came from. So plenty of different remedies. Like I said, people don't realize like the courts at law, the only thing they can do is issue damages. Every
Sure.
other function in the court is an equitable power. If the court isn't like specifically a court of equity, and it just has powers of equity, like all those different other injunctions, those are all powers of equity. So, trust is very, very powerful. Everything is moving to the tune of trust. It's just there are certain bad apples in in certain places that have kind of brought things to the way they are. And but again, people kind of just acquiesce to it and just let it go, slide. And this is kind of where we're at now. So this is why we got to correct it and learn these different doctrines so that way we can enforce, our creator endowed rights.
In your opinion, if let's say I'm someone that's dealing with some matter, it could be an existing case or maybe somebody sued me or, it could be we could just imagine a lot of different scenarios. Do would I have the ability to go into whatever court is in play and somehow invoke the private side, as you said, have a private conversation? Is that an option that's always available, or is it only available under certain circumstances? How does that part work?
Yeah, well, that kind of goes into what court has jurisdiction over the matter. I mean, some lower courts, they're not going to recognize equity no matter what, because some courts are purely, administrative,
Okay,
or in nature. And they, frankly speaking, they just will not acknowledge it no matter what you do. Unless you go with a higher level remedy or something like that, under trust or equity, they're not gonna give it the time of day. I mean, generally
interesting.
speaking, most of the time when you start getting and even an opportunity to be heard in chambers, you start dealing with the trial courts.
Okay,
The trial courts generally is like the first place where that is. Now, I will say though, I think small claims court, I've heard people get some things done there. I don't have I really don't have too much experience with that, but
yeah,
I have heard a number of times when people have gotten certain things done that way. Um, Even if it's just declaratory relief, which is just a decree stating that, something is the case or the trust does exist, or, there's various different implementations of that for that. But, generally speaking, it's the trial courts that start where you start to access equity, And of course, appellate review is equity by nature, as well as Supreme Court is equity by nature. But it just depends at a certain point, what the precedent is. And that is a big key factor is what is the current controlling precedent. Yeah, no, I mean that's one of the biggest considerations there, is essentially, and it's generally under trade secrets doctrine and stuff like that, where you even remotely get access to the private side of equity.
and that's is that not correct that you just mentioned the trade
Yeah,
secrets?
yeah,
Okay.
it is kind of a more a nuanced conversation. So yeah, we will talk about that, soon. So it because it does involve a few different things and just kind of understanding, bare minimum understanding public and private, and kind of moving or things going in between and not breaching. And so it is a little bit more nuanced, but it's more than possible, more than possible. You
If you were on
know.
the street and somebody came up to you and said, I don't understand what you mean by public versus private, what would be your introductory explanation for that?
Well, I mean, most people are aware, the 14th Amendment and kind of the bankruptcies and the various different statutes, that have kind of gone into effect and trading with the enemy and stuff like that. So those have kind of set the stage to where, most of the time they presume you to be, a corporate entity. And if you're presumed to be a corporate entity, you're not presumed to have rights. You're presumed to have privileges because corporations are creations of the state, not creations of the Most High. So that's the biggest difference, is that, they want to delineate that because they don't want to acknowledge creator endowed rights. I'm not saying all of them are just trying to do that, but there is a, kind of a moving agenda towards that, because of the corporatization of society. So,
Yeah, I mean, the way I've kind of seen it from my perspective is they're trying to hide natural law from everyone,
right,
essentially. They're
right.
trying to create
And
a
that,
layer, almost like a shield, where they can't disable, they can't, no man is going to be able to remove the natural law because it's not a man-made construct. But they try to, shield the effect or shield themselves, so that they're able to manipulate the reality in their favor. I guess that's kind of how I see it. Um,
right,
I
right.
see public versus private as, what's going on in the public world is kind of like a fictitious statutory corporate world, like the game pieces, like in on the monopoly board, and private is the real living man or woman. That's kind of how I see it. What are your thoughts on that?
Yeah, that's really how it is. The way that I think Christian Walters kind of expressed it, he said there's, that you have the substantive rights kind of held in private, but they're moved. or given notice in the public via the public deeds or the public titles.
Yeah,
Um, and then that's kind of you have the public side little symbol or token, and then you have the private res that's hidden behind it. That's kind of the how it's been explained to, and there's various different things that kind of go into that, like privatization of estates and things of that nature. But yeah, it's essentially just this big clear divide. When you start learning the truth and what they want in the public, and then what they don't want in the public, and that is the dividing line. There's certain communities that know about certain things, and others, why different groups of peoples and different leaders have kind of been removed, especially from political, aspects of it. But yeah, that's kind of just this corporate veil that they've intended to put over kind of the whole realm. So if you haven't got through to that other side, or it don't apply to you, you're kind of in a whole separate realm.
I agree with that. So when someone says you can't mix public and private, how would you like how do we come to understand that?
So that really goes into kind of thinking more about the public trust versus private trust, right? The word republic actually comes from the word re publicae, or res publicae, which means public res, or public thing, a public
Yeah.
trust. It's
Okay.
essentially just a repurposed thing that has been set aside under trust. Now, you have that aspect of it, and then kind of goes into how the corporate side of, what they call corporate America, is that overlay. So the way I like to think about it is each one is it's technically its own trust, right? There's certain
Yeah.
things that are allowed to be put in the public realm under, various doctrines, national security and all, whatever they try to invoke, necessity of use, emergency doctrines and things like that. And then you have the private, which is where all of the original things are held. You know, that's where all the substantive rights, all the substance of the law is
Yeah.
held.
Yeah, it's
Because
like
I don't
the paradigm of spirit versus matter could be an analog to
right,
that.
right. That's a very clear, correlation between the two. Because yeah, yeah, and I don't think that people really realize that these different things actually exist. It's hard because people are taught to be so materialistic that they don't really consider anything internally. They don't consider things, in the mental plane, but it is an actual plane of existence. Like it does actually exist, just not in the way that we see it corporeally. That's one of those things there. I really just don't think people think about too much, to be honest. Get down.
100%. 100%. Yeah. Well, it's about raising awareness. And we're coming up, we just finished about an hour. How are you doing so far as time be? Are you good to keep going?
Yeah, I can keep going.
Okay, great. Now, just out of curiosity, do you spend a lot of time in court? How much time do you actually spend in court?
Like I tend to let my documents and paperwork, do the talking. Yeah. And that's the way that I prefer to appear is by evidence.
Sure.
When you properly present yourself before the court, special appearance and then under trust, the jurisdiction is that where your paperwork speaks for you. So there's a plenty of times when you don't have to physically appear if you've already entered an appearance
Yeah.
properly and you've already made the substance of your argument or your brief, whether public or private, before the court. And it provides a lot of power to be able to enforce it, because then it's like, okay, well, it's not so much theater as it is to just point for point, okay, well, what is it this party says? And it's more just the paperwork itself, because that's the evidence of the intent or the writings or the claim. So the actual, just understanding, that aspect of it, the documents are really what speak the loudest, even though a lot of times you do have to kind of, reiterate what you're saying, orally in court sometimes, depending on the type of appearance that's necessitated. But generally speaking, your paper should already say everything that you're looking to say verbally, on paper ahead of time.
One of the other educators that I've been learning with, you may or may not know who they are, um, basically kind of painted a picture as though you can't really bring equity, or at least they're not aware of how to bring equity if you're filing anything in the court as a plaintiff. What's your thought on that?
Well, and yeah, it really does go back to essentially trade secrets doctrine. That is kind of what it allows certain evidence to be even brought under seal. Um, it's kind of a overlooked doctrine. I mean, most people really, most of the time, aren't looking to the corporate side of it because that's where it's most used. But it's available there, and especially with trust, which already has the presumption of privacy, especially with private trusts. Yeah, it's something there that can be used to enforce those different trust interests.
And again, that's something that we're going to be discussing in our private Telegram community coming up. So we'll obviously let folks know about that. So awesome. Just going back here, there was something when you were talking previously about the grantor
Mm-hmm.
in their proper role. What is the proper role of the grantor in context to a trust?
So the grantor is essentially the one granting the res or the thing into the trust. So the way that I like to explain trust and the three general parties to it, I like to think of the grantor or the settler. They're two different terms, but they're really referring to the same party. The grantor is the king, right? The trustee is the servant to the king,
Yep.
and the heir or the beneficiary is the heir to the king. So when the king or the grantor gives something to his servant and says, this is to be given to the heir. So let's just for an example. So A is to receive this particular pen, if you will. So I give you this pen and to give to the heir A in kind and in the same condition. So that's one of those instances where it's a little bit more of a kind of just a passive trust where the title just flows straight through and there's nothing really done by the trustee. The grantor is essentially the one with all the power because of what's known as the right of disposition of property. If a thing or property belongs to you, you have the right to do whatever you want with it. And that's kind of where that doctrine comes from. Um, so every man is king in his own house. So that kind of allows you to be able to say, okay, well, I'm going to set aside this particular property ahead of time. I'm not going to change my mind. It's irrevocable. It's to be done with, and to used in this manner and delivered over to said beneficiary or residuary beneficiary or what have you. So, let's say, for example, that, I had a, I don't even know, $5,000 Mont Blanc, pen. And I say, hey, I'm giving this to you, the servant, trustee, um, and I want you to go and convert this to capital and invest those funds for the benefit and the use and the maintenance of A. Well, then my intent and purpose have kind of set aside that the trust is there for the purposes of maintenance of the beneficiary and also raising capital thereof. So that is, set those different aspects for the trust as it is.
So, but when the trust is irrevocable, the grantor can certainly express all their wishes, but once they've released it, they've basically relinquished control, right?
Yes, with respect, yes. So in that case, it would be entirely set aside, as its own separate trust or its own separate, you know, if you will, like recognized, persona in law and equity. And, the trustee would be the sole owner with the benefit going to whomever is entitled to it, per what the settler intended. But could the settler revoke that? No, not in that instance. So, that's one example. Um, another example, of a simpler type of trust, where, the settler is also the beneficiary is kind of, if I said, hey, look, I'm giving you this pen, you can use it, do whatever, as long as it's returned to me in kind and in the same condition, you know, there's a special deposit because for one, it's a specific purpose that's being used, but the pen is to be, returned in the same condition, with reasonable care. If it's something more expensive, then you do have to make that express and a little bit more well known. But it just and it's kind of understanding that from the onset, how to properly express that relation, so that way it doesn't just remain kind of as a general deposit.
Right, and I think if the trust, as I've come to learn, if the trust is set up correctly, even though it's irrevocable, that doesn't mean that it's that the trustees wouldn't necessarily have the ability to sell off certain assets, buy additional assets, and
Right.
basically completely change the res of the trust in a way, as long as it's all being done to the benefit of the beneficiaries. What would be your thoughts on that?
It really just depends on what's expressed in the trust instruments. The trust instrument is going to be considered like, the controlling law, especially like any declarations or any express intent, from the settler or the grantor. Because if it says in the trust instrument that they can do that, they can do that. If they can't, or if it's a little hazy, that, and this is this is with express trust. It gets a little bit fuzzier when you start dealing with constructive trusts or fraud
Yeah.
resulting trusts, arising from operation of law. But express trust, yeah, it's all per the terms of the trust instrument. Whatever's dictated in that agreement, or that those writings that the trustee agreed to, you know, that's that's essentially the last say on it.
What would be like what are some mistakes to avoid that would make a trust unenforceable or more likely to be pierced in court?
One of the most obvious ones off the top of my head is having a clause in there that violates the rule of perpetuities in a jurisdiction where the rule of perpetuities has application. So, under specifically the common law, there are there's like keeping trusts under 20 to 25 years is kind of almost a necessity. I think Christian Walters did talk about it, but Carlton Weiss in his that Weiss Concise, that book, he kind of shows in the examples that he provides in there, kind of how that's done. This is kind of why you have this prestige of different businesses and the public kind of, slightly change the name or add something to it, or, something like that. Um, that's one of the biggest things. The other aspect of it is, not breaching a private trust, because private trusts are more not just what you do, it's even, just as much what you don't do, because it doesn't really require much to breach it. So you kind of just have to know, what how little you actually need in the public, and don't give them anything more than the bare minimum, for especially for a given transaction, and then making sure that those transactions align with the trust intent and purpose, and that you're within the authority that was, granted if you're acting as trustee. People are opening up even trust accounts. Most of the time, people don't realize that you don't really need anything beyond a certificate of trust and an EIN. Most of the time,
Yeah,
there are maybe
that's been
some
my
exceptions,
experience.
but yeah, you really don't need much.
You
And
certainly
it,
don't want to give the bankers the entire declaration of trust, or really anyone if it's private.
no, no, and there's select occasions where people hire them. Not necessarily like the private sector, if you will, but more of different maybe certain levels of government where you might want to express that properly, kind of as presentments maybe or something, kind of just to show your intent and purpose, but it has to be done in a very controlled manner. So it's usually it's an exception, generally not the rule.
Sure. And I've heard cases where you might offer like a part, either certify or offer a part of the declaration in order to satisfy a requirement, but again, it wouldn't be the entire trust
Right,
itself.
right. Because and yeah, because your actions or conduct will determine
Yeah.
a lot of times, most of the trust and how it's treated. Because if the trustee treats it like, oh, it's just willy nilly, then they're gonna kind of look at it the same too.
Going
You
back
know.
to what you just said about the best practice of not having the trust last beyond a certain number of years, what would be
Mhm.
the best practice to keep property in trust then? Are new trusts just going to keep getting declared every 25 years and then doing an exchange into the new trust, or what's the best practice there?
Like in that particular like specifically the common law to with some, I guess, some context into still maintaining private, but it's under maybe like a law form where you may be invoking, I don't know, the UCC or some type of corporate interest. Yeah, that type of thing is going to be pretty strictly. You have to do something. It sells it to another trust, and before it expires or something, a lot, something of that nature. But that's specific to that. There are types of trusts that continue on in perpetuity, and there are certain types of trusts that can last much longer than just even 100 years. There are some places they are statutory in nature, but they can technically last. I don't know. I've heard anywhere 500 years. Maybe even longer. I've heard of some different things like that. It just
Okay, but
depends.
just to clarify, so could a pure equity trust last that long, or
As
that's not?
long as the trust is not doing, as long as it's not doing any commerce and it's entirely out of the public realm and, it's entirely set aside and it doesn't commingle or breach, then technically, it could do that. It just has to be done properly. And, the trust instrument it has to be drafted
So, like a
specifically
trust
for
that's
that.
holding property, for example, but not doing commerce with the property.
Yeah, I mean, there are some requisites, but you could do that. It depends. Not directly owning, maybe owning the entities that own it, or something of that nature, or some type of higher, farther up the chain in the company structure. It would probably work, but like I said, it just has to be. You just have to cross all the T's and dot all the I's in that regard, because you're dealing with the kind of the different jurisdictions at that point.
Got it. This is all new for me, even having studied trust up to this point. That's the first time that I've heard about this, issue or practice with the time limit. So definitely something that I'm going to look into. And you had mentioned
Uh,
the other one other way is, of course, violating the terms of the trust. What about best practice around assuming more than one role, like being the grantor and the beneficiary, for example? Are there any issues there?
Sometimes there can be, to be honest. The safest way to do things is to express it generally with one role. The only time I've seen it as well, no, there's two different types, but generally it's with regards to like the Cesta KV trust or, the legal estate, that all capital letter name. That's the time when I've seen like you could do two roles because of the dual,
Yeah.
nature of things. With regards to just other people and interactions with the public and other times, most of the time, no. Yeah, I've seen executor and sole beneficiary with regards to the minor estate, because the executor being essentially is seen technically, or the estate seen as the settler. So the executor would be the nominee
Interesting.
grantor, if you will. And then, the trustee being whoever is holding the property, and then the estate again being the sole beneficiary. So that goes back to the executor. So the executor would be then under trust, which is subordinate to the estate, would be you'd have again them as the settler or the estate as the settler and the beneficiary. So that's why you have the dual nature of that. That's one example of that. The other time I've seen it work is if you're claiming, well, there's sometimes that certain things with the grantee position, I believe more than one time you can claim several roles. I think it might be grantee and beneficiary or something like that. But it just depends on the transaction, realistically, what you're really expressing and what you're intending to you know perform.
Sure. And one of the things I'm realizing is, like you were saying earlier, I mean, because it's essentially a private contract, there's many different ways to set it up. And for example, one of the other educators I've learned from, they actually discourage people from even being their own trustees and just take more of a general manager role to further separate themselves. I'm curious if you've ever heard of that perspective as a best practice, or what your thoughts are.
That's yeah, I've definitely heard that. There's certain types of trusts that can appoint authorized representatives,
Yeah,
and that is it's not a bad way to deal with certain things like that. You're specifically there just to represent the settler's intention at that point, and then you're able to just conduct it. You're like, okay, well, I'm not here to construe it or misconstrue it. I'm here. This is how it is. He's either gonna do business or do whatever, or have the interaction or not. Or in certain instances, it can help to protect that because that's all your function is and that's all your role is. At least expressed at that time. And authorized representative, it has its roots in the UCC, under that specific, like, the statute or that particular code. But, just the title itself, just being a representative is not necessarily just statutory per se. So, it works technically on the law of agency. So that's in that regard, but there's ways to kind of present it under trust that kind of mitigate a lot of those things.
there's a maxim of commerce that I've heard. I think it's one of the 10 maxims that talks about the measure of a man's credibility is the sacrifice he's willing to make or the risk he's willing to take. Do you think trustees should accept full commercial liability for breach to the point where they would be indebted in real lawful money if they were to breach the trust? What are your thoughts on that?
Just depends on what is being held in trust. If it's somebody's life, then absolutely. Um, if it's, I don't know, some menial amount, 20 bucks or just, some small petty sum, wouldn't say so, but to say that he's not liable, at least to make that good, financially, no, I would say he's still liable. But I would say just according to whatever was entrusted to him, I would say is generally the standard that he should be held to. The duty,
Sure.
because it's under the duty of care and um yeah, it's the duty of care and duty of good faith towards the beneficiary. I believe is the two doctrines that control that. Um, and they because the duty of care is essentially the prudence that a trustee has to exercise in raising capital or raising funds, with regards to a trust. And
Sure.
the duty, of good faith in regards to the beneficiaries is, maintaining clean hands and, good faith dealings with regards to the representations and the conduct, between the trustee and the beneficiary. So, yeah, I mean, they should be held accountable to whatever it is they are. Hopefully it should never get to the point of breach. But
Of
realistically
course.
speaking, if it does get to that point, yeah, I believe they should be held liable because you do have to, the trustee has to agree, whether they just dishonored the presentment or whatnot, or, they have to agree somehow, so because they
Sure.
go into it willingly, however that they consent to it, yeah, I really do think, yeah, they should be held to that higher standard. Because again, it's like otherwise it's just a breach of trust, and the trust fails.
One of the things that I've said is I think there's going to be an explosion of like people becoming trustees as more and more people start to master this. What's your thoughts on that? Do you think there's going to be a shortage of good trustees? Is that something that's coming up?
I think we already are in a shortage of good trustees. I mean, because there's a big difference between being a trustee on a private non-statutory trust, or just a private express trust, versus, the just a public statutory trustee, because on one side you have a trustee in equity on the private trust, per the terms of the trust instrument, and then, statutory trustees, it's your kind of hand in hand, again, under the state, you know.
Yeah.
And yeah, I think there is a huge shortage of it right now, just as it is. This is again why you have to have that personal status, because the trustee is seen as the legal owner of the trust. So
Yep.
if your status is domestic, and you're not really able to protect anything if you have no standing as it is anyway. So correcting that, in trust, and properly conveying the estate into an equitable one, and things like that, it does make a huge difference as far as, how things, are protected under trust.
And that's something that you're helping your private clients and students to do. Is that right?
Absolutely, absolutely. So, I focus on the doctrine, but like I said, I'm not just doctrine. I really do. I execute various different things at pretty much all levels. I just handle things on a case by case basis, and just kind of hear out whatever it is, and then you know, generally things have to be handled according to that situation. It's not generally like a blanket. There are certain things that are very similar as far as that, but once you get into direct application, there's specifics to any situation, you have to take a look into. But yeah, that's something that I do, and I teach people, according to just trust, and other equitable principles and doctrines, and not to be able to affect what frankly should have just been from the start.
Awesome. Yeah, I mean, I totally agree with you. And wow, I've learned a few things, even having studied trust, we're always learning new things. And I've definitely derived some real gems from what we've discussed. Let's kind of shift and then talk about, we're going to share some links, obviously, to your website and your YouTube, so people can find that. But maybe just
Mhm.
share a little bit about your platform, your ecosystem, how people get involved, what that looks like.
So yeah, absolutely. And like I said, even though I've been studying for this amount of time, like I said, I'm still a student. I'm learning every single day. Just because
Same.
I've done all these different things, like it doesn't mean I know everything. I still have to look up, okay, what is the statute here? What is the precedent here?
Yeah.
What is the, and kind of, operate that public side accordingly, and still preserve the private interests, so you never stop learning. It's, that being said, like I said, it doesn't take years to learn, but at least to get a handle on it, it doesn't take that long. You just have to know the principles. But yeah, as far as what I've been doing, I do have my YouTube channel. I've put a lot of, I've elaborated on the Cesta KVX, and a few other things as far as the historical aspect, because I've always been kind of a why, type of guy, and I just had to, for me, just to even get an understanding, I just had to know why. It wasn't really just to always question authority or or whatnot. The wrong authorities, of course, they kind of have to ask where do they derive it. But yeah, I've looked at it from that aspect. But I have the YouTube channel there. I do have a Telegram call on Thursdays, in a private group, called the Archive. It used to
Yeah.
be called the Exclusive Equity Live Discussion. So I just kind of had to rename it just to make it easier to say.
Yeah.
um, I've done, let me see, a lot of my a lot of my clients I do generally with just one-on-one basis. And then I
Awesome.
am moving toward. I do have a mentee program. It is, a little bit more just because it requires a lot more time and resources from me. But I have different things for various levels of engagement. But generally speaking, I just tell people, set up a consultation, and just to see where you're at, and kind of see what's best for your situation. Um, and then move on from there. So that's been my focus, because a lot of this stuff is very, very high level, and it's hard to teach in a classroom setting unless it's small. So I've kind of
Okay.
just been moving towards a private mentee model, and then I have my the Telegram group and then some existing relationships there. So
Amazing.
I
Yeah,
mm,
I'm right where there with you, B. I was not super keen on doing one-on-one, just, seeing it as not being maybe the most efficient way of doing it. And we will continue, we'll at the Freedom Studio, we're going to continue doing groups conversations. We're not going to take that away, but I much more appreciate the value and power of one-on-one. I recently found a new mentor for myself,
that's
and he
good.
has the
Yeah,
same. He's got the same philosophy of kind of the power of working with someone privately is you can go so much deeper. So I can completely relate to that.
yeah, and there's a lot of things that and just from my experience with teaching and sharing with others, like there's a lot of things when you try to share things with people, there's a context, especially when
Yeah,
speaking, that has to be, it's really hard to convey it unless you're speaking personally to someone, so
sure.
that they, because some things are heavier than others. There's some situations that have a gravity to them that really can't be expressed any other way. So that's kind of why do that. And like I said, there's certain things that you can absolutely teach in groups, in trust and equity. It's just the level when you start really dealing with like ecclesiastical equity and trust that aren't registered with the publicly in any
Yeah,
way, don't get any even an EIN, for an example. Those have to be administered entirely different, and it just
for
requires
sure.
an entirely different train of thought that it just it isn't. It's like another level. Like there are levels to it, and it's not to exclude anyone. It's just because that's just the way things are, and so it just requires a
100%.
level, just a little bit more understanding in certain areas.
I agree with that wholeheartedly. And yeah, even sometimes with doing a private consultation, not necessarily in context to ongoing mentorship, I feel like even with 1 hour consultation with individuals, I'm able to help them go so much deeper and unlock, solve problems and move forward much more effectively than we would ever be able to do. The group classes are great for teaching principles and concepts, but it's never going to be
Right.
personalized to the level of what any particular man or woman may be dealing with in their own private life that could be inhibiting moving forward. So we always need to have that context, in my
Yeah,
opinion.
absolutely. And it's like, and there's so many, and trust is special, right? It's species or kind, like
Yeah,
in kind deposits. So especially when you deal with that, it's the specifics change, like even what you do in that situation. So it's like that's really why, because eventually you get to a point where it's like, okay, well, now everybody's just got their individual situations, so it's like kind of have to talk about those individual things, because the public debtor creditor is more of general deposits, but trust is
yeah,
entirely special in
yeah.
nature, and because and that's another thing that people I think people really should know about is that, general deposits, even Baylor Bailey relationships and debtor creditor relationships, they're all, you basically give up title to the deposit if you make a general deposit. So
Sure.
let's say, for example, I had $100 and carte blanche, no restrictive endorsement, no
Yeah,
endorsement as the trustee, no, not as authorized representative. I just give $100 to the bank. Well, then the legal title to that individual $100 is they own that deposit. So then the only thing that after that point I'd be entitled to would be I wouldn't get the same $100 bill, that I'm putting in there, or the same check. I would only be getting a general credit for $100. So that's debtor creditor. But let's say, for example, I don't want to treat it just like that, and I want to preserve the original $100 bill or the
yeah.
original check, then it has to be treated, as a special deposit, or, in some type held in some type of manner that clearly denotes that this is, in that this is held in that manner, and that the title is retained, by the grantor, or
Yep.
if acting in on behalf of the trust is retained by the trust. And so it's that's one of the biggest things there. It's just, and the trust is always special. So if the trust is retaining the title, it's always conditional. It's always controlled in that manner. So it's a different line of thought. And I think that the mentality, I mean, that's really the biggest thing that I see with most people. It's really not the processes, or the doctrines, or even the methods to it. It's really just the mentality that people have. It's going from just the
100%.
kind of, and oh, it'll all be all right. You just throw it all together, kind of a jambalaya type thing. Like, no, it don't work like that. You have to
That's a
tailor
good
it.
way to shoot yourself in the foot as far as I'm concerned.
Yeah. No, it really is. That's how you commingle. If you make jambalaya instead of trying to cook up the grill one piece at a time, yeah, it is gonna come out like that. So yeah, yeah, and
Now, if
that's.
you're looking to eat jambalaya, go ahead to your heart's content.
I mean, I don't eat that stuff. I don't eat meat or
Me
dairy or
neither.
anything like
Yeah.
that. But yeah, I was just saying that for an example. But yeah, it's just like, yeah, people. I think it's just a little bit new to people, but like I said, it's foundational. Like we should have been taught this, from the
Sure.
start. But so we're all playing catch up to some degree. It's just, when do you start? And yeah, for me, I had to. So
Yeah, it's like you're compelled to because it's your calling.
right. Well, not only that, but my situation kind of demanded it at the time.
Sure.
So yeah,
Yeah.
I was dealing with I think a divorce at the time, and that kind of taught me a lot. So.
Awesome. Awesome, B. This has been really valuable, and I've learned so much. And yeah, I mean, this is the power of alliance, of collaboration. You're an educator. Um, I'm an educator. You've been taking action, learning, and continuing to learn, and then helping. And I have each in our own way. So I think it's important that in this overall movement to generate more freedom and to bring everything back into alignment, pull down, have the higher force, be more present in our world. We've got to have each
Mhm.
other's backs. We've got to have each other's backs. In my
Yeah.
opinion, we've got to support each other. It's not about trying to create our own, one world alliance. Everybody's doing their own thing,
Right.
but it's not a collectivist thing, but it's more of a collaborative thing where,
Right.
everybody's showing up in their with their unique skills, and we're, helping each other out. So
Right.
that's
Right.
that's really been the
Yeah.
spirit of substance. Now, just as we wrap up here, we're definitely going to share all the links where people can follow your work to their heart's content. Any last thoughts that you'd like to share in the spirit of what we've discussed?
I think a lot of it can be intimidating, especially at first. It's all new. It's kind of like jumping in a pool, really cold, like 50-degree cold water. You kind of just gotta jump in and start swimming. I know it's uncomfortable at first, and it's a lot of times a lot of times,
Yeah,
like I remember, like when I first started, I had to look up every single word of every single sentence, and I was like, oh my word, like this is wild.
yeah,
Because everything has its
a
own
lot.
definition, and things have been redefined to a great degree. So it was intimidating at first. I would just say to
Yeah,
people, don't give up, just study, don't assume anything. If you don't know it, just look it up. Just ask the
yeah,
question, and you'd be surprised, when you put in diligent study and you have the desire, because you got to want it. If you don't want it, it will never there. Like there's we're not supposed to be living in artificial scarcity as it is. Like, the way that people need to be reclaiming their inheritances is through trust. And believe it or not, there's stuff set aside, that people just really don't think about. So, just don't give up. Like I said, study the principles, study the basics. I know it seems like, oh, you just want to jump to the end and do it, but that is how you actually
you don't watch a
get it
movie by
done.
starting at the end of the movie or reading a book.
Right.
Go through the
You
process.
gotta, yeah, you gotta watch the whole movie. You gotta read the book. It's and then just knowing what to study is the other thing. Like I said,
Right.
the different resources are a good foundational aspect of it, and then law reviews, especially regarding trust, are excellent. There's a bunch of them by Harvard and Yale and
Yeah.
Penn Law Review and all these different. Those are an excellent resource. There's honestly even attorneys' websites. Actually, they do give brief descriptions and there's a few different things there that you can look into as far as researching that. But just having that
Amazing.
appetite for knowledge will take you a long, long ways.
Amazing. Very well said, B. I appreciate that. I love the fact that we were able to collaborate in this way. And I just want to invite you, the viewer or the listener here, go follow B's work to Be Fruitful Training. Like I said, we're going to provide some links below the video so folks can find that. And then from there, you'll be able to dive in deeper. But go support his work and that community because together we're going to be able to grow and we're going to be able to make this happen. Remember what B and I were saying earlier. This could all be turned around in a day. I mean, I know it's hard to believe, but I'm not saying that's necessarily what's going to happen. But let's aim high. Let's set our standard pretty high. So B, I super appreciate you dedicating some time to have this conversation, and I know folks who are going to watch this are going to get a lot of value. So I wanted to thank you.
Well, thank you for having me on. I'm grateful to be able to share with others, and yeah, it's been a pleasure.
Awesome. Okay, so everybody stay tuned for that upcoming conversation with B on our Telegram, and we'll talk to everybody soon. Take care.